Hello, everyone, and welcome to Subro Sessions. And welcome to the start of a great series within Subro Sessions titled Subro Trauma Center. Discussions on common issues that arise in subrogation claims and how to address them. My name is Gus Sara, and I am joined here today with my fellow partners, Matt Ferrie and Lian Skaf.
Hello, everyone. This is Matt Ferrie. Great to be podcasting with Lian and Gus again. We got the band back together.
Hi, this is Lian Skaf, and let me just say that Gus and I are particularly qualified on this topic because we both have wives that are nurses, right, Gus?
Yes, that is true. And welcome to the Subro Trauma Center, where we analyze common symptoms of subrogation claims, diagnose the problems, and proceed to treat the issues for a full or sometimes partial recovery. The topics for each episode of this series will be determined by you, our cherished listeners. We have already received a few great topics from some of our listeners, but there's still room for more topics. And we encourage you to reach out to either of us or any of us directly if you want to hear anything about or more on a discussion for any particular subrogation-related topic. Today's topic is part one of the series and is titled Subrogor Problems, Handling Claims Involving an Uncooperative or Difficult Insured. It almost goes without saying that the insured is one of the most, if not the most important piece to the subrogation puzzle. We'll briefly discuss the reasons why the insured is so integral to the subrogation claim, and then we'll go into what can happen when the insured is difficult or uncooperative, which can be devastating and sometimes fatal to a subrogation claim. We'll be discussing the ways in which issues can arise with the insured, and we'll provide tips on how to address these issues. We will also be providing examples from our own experiences, which I think you'll find insightful. So to kick off here, Matt and Lian, why don't you tell us why the insured is so integral to subrogation claims?
Yeah, so when we first got pitched this idea, it was pretty much a no-brainer. The insureds are so important to everything we do, from our investigation process to any sort of litigation, on the liability side, on the damages side. They're just very, very important, critical witnesses, especially when we're talking about events leading up to the loss. A lot of times, after the loss, you get different perspectives and opinions from experts, adjusters, public sector people. But leading up to the loss, it's oftentimes really just the insured. So, they are critical witnesses to give you background on the events leading up to the loss to help you develop your investigation. Oftentimes, they're a witness of the actual loss itself. Maybe an eyewitness fire, or, they may be the first one on site to see some water damage. And as far as damages goes, the insured is your person that's going to have a lot of the photographs, the invoices, the receipts that you're eventually going to need to support your damages claims.
We could go on and on about how important the insured is to a subrogation case, probably knock out about 20 different bullet points. Just to highlight a few others, and Lian touched on this, the importance of an insured for the damages aspect of the case cannot be overstated. They're the person who is the most familiar with the contents in their home, the condition of those contents, what they paid for them, and honestly, the personal value to them in case that becomes a damages issue as well. Also, the insured is usually the first witness who is deposed in the litigation. They kind of set the tone for presenting your case through depositions and how you want your case to come across to the other side. So, Gus, why don't we talk about some of the common issues we face when insured's cooperation is not exactly going how we had hoped?
Yeah, the first topic we're going to be discussing is the difficult adjustment process. And, that can come into play for many reasons, including insured is discontent with how the first party claim is being handled. If the insured does not feel like the communication with the first party adjuster is sufficient, and for several reasons. And Lian is going to share an example that he has experienced dealing with this particular issue.
Yeah, I think even on the smoothest adjustment processes, it's still going to be a difficult time. Anyone that has handled subrogation claims knows that it's a very stressful time for any insured involved. Anyone that has their own insurance claim knows what a stressful time it is to have this extra and usually unanticipated layer of a subrogation investigation going on can be really stressful. So it's not uncommon to have an insured who, again, even if they're having an okay adjustment time, to kind of be a bit stressed when they're talking with you.
All right, now we're going to delve into the issues that arise when you have an insured that is problematic or uncooperative. And one of the issues is a difficult adjustment process. The insured is either discontent with the first party claim or feels that the communication with the insured is not ideal or sufficient, and the many issues that come along with that. Lian is going to tell us a story that he had dealing with a difficult insured during the adjustment process.
Yeah. So, anyone that's handled subrogation claims or even had their own insurance claim knows that going through this process, even in the smoothest of times is difficult. So, having this extra layer of what is generally frustrating and unanticipated subrogation investigation just makes that even more stressful. So, recently I had a claim where the insured was having a really difficult time with the adjustment process. They were fighting over valuation, about what was covered, what wasn't. So, when we pop in with our subrogation investigation, it's just like one more thing on top of the pile that they had to deal with, and they were not happy about it. In particular, the time that we had to hold the scene to get our experts out there, to put people on notice, to do a joint inspection. And they were, voicing this frustration to the carrier. So I think really the only way to deal with that kind of thing is not to ignore it, not to run away from it, but to talk to the insured. To a certain extent, as a lawyer, our job is to kind of take the sword there and tell them, look, this is us doing our job. This is how it goes. We're the ones that, if you want to yell and scream at, to do it, not the carriers. And, to keep them informed about each step of the process and why we're doing everything. Why is this taking a month? Why is this taking, a few weeks to get people out there? And just let them know that, this is not an attack against them. This is not, any sort of retribution for the adjustment process, how good or bad it went, but just what we have to do our jobs.
Absolutely. And I think the idea of communicating is almost always going to be the right answer. I mean, I've found in my experience in subrogation, and really in just about any situation, is when someone's annoyed about something that's going on, they want an explanation. And they might not always agree with the explanation. They might not, like the explanation, but just the fact that it is explained to them that there is a justification for why this is happening tends to smooth things over a little bit. And so the sooner we can do that, and the more communicative we can be early on, I think you can avoid a lot of the hard feelings that might otherwise develop.
Yeah, it always benefits to contact the insured immediately, explain the process, even though the first party adjuster may have as well. It doesn't hurt to reach out, introduce yourself, and let them know the process. And I tend to give the insured a time frame, and I try to overestimate a little bit, so that we don't set unrealistic expectations. And doing that on the onset might help prevent some of these issues. Moving on to the second issue, insured claims uninsured losses that are questionable. And unfortunately, we tend to see this more than we'd like to acknowledge. And I have a particular case recently in New Jersey where the liability was good. It was a residential fire originating in a recliner chair. Our investigation indicated that the fire originated in the heating elements for the recliner warmer feature for the chair. The insured witnessed the events, and her kids were home, and she was able to safely evacuate with her kids. But I learned after the adjustment was finalized and we submitted a demand to the targets, to the manufacturers of the components for the recliner, that the insured retained counsel to pursue an emotional distress claim for witnessing the fire at the recliner with the presence of her children there. And while there were no physical injuries, the insured is claiming emotional distress claims, which is going to undoubtedly cause delay in the resolution of our property subrogation claim. Unfortunately, the best thing to do in this situation is to cooperate with the insured's attorney include them in the process. They're not going anywhere. Perhaps if you get to a point where you have a good enough rapport to explain that perhaps their demand is too high or that their claim is questionable and that they need to compromise on the claim, then that opportunity should be taken. But those kinds of examples where the insured can cause delay in the resolution of a subrogation claim, even if liability is good and damages are straightforward.
And another aspect of that is when you have an insured that may be seeking something that's sort of unreasonable in terms of out-of-pocket loss, is your hope is that if the jury views that as unreasonable, that their testimony about the aspects of the case where you do need them is not tainted. Testimony maybe in terms of their observations of the fire, testimony in terms of the extent of the damage that was covered by the insurance carrier. So there may be opportunities for you to ask questions of the insured where you can really kind of solidify certain aspects of their testimony, even if some other aspects are not as easily accepted by the jury.
That's a very good point. Moving on to another issue that tends to arise. The insured is simply unwilling to cooperate in the subrogation lawsuit or the subrogation efforts.
Yeah, and Gus and I have all been doing this Lian and I have all been doing this a long time, and we've all seen all kinds of different levels of cooperation from insureds. And I think what you generally see is it's sort of a spectrum. On one end of the spectrum are your gung-ho insureds, the ones that are all about subrogation, happy you're there, want to support you in any way, thoroughly believe that the target caused the damage, and want the target to be held accountable. And you have insureds who will constantly be calling you about, what do you need from me? How can I help? When are we going to get these guys to pay up for what they did?
A little too gung-ho.
Yeah. And the funny thing is, as much as you love that
constantly calling maybe much, but
Yeah.
Sometimes you have to kind of explain to them even with a good case, this could take months, this could take years. So, but you're happy to, that's better than the alternative. You're happy to have a gung-ho insured versus one that is not, interested in helping you. One level below that, I would say you have your generally cooperative insureds. They don't necessarily understand the whole subrogation process. They understand you have a job to do, and they're happy to help you in whatever way they can. They're great.
The ideal insured.
Then you have maybe the middle of the spectrum. You have the insureds who understandably are very preoccupied with everything else that's going on in their lives because of this incident. They're not necessarily thrilled about subrogation being involved, but they'll do it. If they're not hiding from you, and if you keep reaching out to them, they'll do what they need to do in order to cooperate with the investigation.
Perhaps with a little attitude.
Perhaps, and kind of hard to avoid sometimes. Then below that, you have the insureds where it really can be like pulling teeth to get their cooperation. They might ultimately do it. They might eventually do it, but if they do it, it's kind of half-hearted. They're not giving you what you need, and it can be frustrating for a case that may otherwise have a lot of merit to it. And then at the far end of the spectrum, you have your insureds who are downright hostile. I remember when I first started working at White & Williams maybe 15 years ago, I was working on a case with a partner, and the partner had a conversation with the insured on the phone where the insured actually said, how can I prevent you from doing what you want to do? I would like to be as much of an obstacle as I can.
Were they successful?
Yeah. How do you answer that question? I don't think it was a big recovery, ultimately. but
that probably had something to do with it.
At least kudos to them for their honesty.
Yeah, no, I mean, along those lines, I recently had a case where the insured just refused to cooperate at all. Didn't return calls, didn't return emails. And, we knew that the insured was receiving the letters. It involved a underground oil tank that started leaking in a home that the insured had just recently purchased. And the insured had small children. And unfortunately, because of this incident, they had to dig a giant hole in her backyard that lasted longer than she wanted to have a giant hole in her backyard with little kids running around. She had just bought this house, so she was traumatized by the whole event, and appeared to me that she simply did not want to relive these events. She wanted this claim to go away. You were able to tell in the claims notes that she was extremely frustrated with the whole process because when you have an oil contamination, you have to notify authorities and the state has to clear it before you can start repairing and putting a new tank in and filling in the hole. So, when it came down, and we're going to talk about releases, but all the way through the release, I had no insured, which caused us to have to discount the claim in order to get it done because the other side did want to depose the insured. So it created a lot of problematic issues, and I had to settle it before I had to come clean, which could have been devastating to the case if the defense attorney knew that the insured was absolutely just MIA. So definitely an issue you got to look out for. The best way to handle it is do your best to work around it. You don't have to, make an announcement that your insured is not being cooperative. It's something, if you could brush it under the rug with the other side, you might want to do it and get the case settled before it comes to light.
Sometimes people are unwilling to help because the person you're pursuing may be sympathetic to them, whether it's a friend, whether it's a company they like to use. In my case that we just recently worked with, it was a father-in-law. So our insured had a fire in the house, and our initial investigation revealed that the work that her father-in-law was doing may have been the cause. So we ultimately decided he did have separate insurance, that we were going to pursue that, investigation. As you can imagine, the insured was not happy. On top of losing her house, her valuables and everything, her insurance company was now looking at her father-in-law as a potential target here in subrogation. So I got a long, upset voicemail from her when, I think probably justifiably, or at least understandably. And, I really, could understand it. And I really did not look forward to making that return call. But I think, it's important to deal with that kind of situation head on, to keep the lines of communications open. So I did call her back, and I did explain to her that, this was part of our process, that, we weren't out for anyone, that, we're going to let the evidence kind of reveal itself, and we're just going to, follow whatever theories our experts have, that we're only dealing with, his insurance company, that we're not jumping to any lawsuits. And anyway, the bottom line is that, once I kind of explained to her the whole process and kind of told her we're doing this step by step, and I kept her informed at each step, she understood. I mean, obviously she still wasn't happy with what was going on, but she understood why it was happening and when and what was happening. And ultimately it turned out that, it wasn't his work that was the cause, and we closed the file, and I let her know that too. And I think ultimately she was fine. Again, you're never going to make her happy. You're never going to make someone in that situation happy, but at least they understand and they're being told, not patronized.
I'm sure she has fond memories of you, Lian.
Unforgettable. And there's
everyone likes their in-laws too, so maybe they want them to be pursued. I don't know.
There's also those instances where the insured has a business relationship with the target, a continuing business relationship, and may not be happy with the fact that the carrier is subrogating against that entity. I've had that happen several times. I've been able to survive it. It's something that you can persevere through. You just need to be aware of the situation and tread lightly when approaching the target, and make the client aware that this is an issue that could come up and could be a problem at trial or during depositions. Moving on to the next issue, which is a very important issue, the insured it turns out to be an unreliable witness. And Matt, I believe you have an example for it.
I do. And this is extremely important because, we want to remember that ultimately, although very few cases go to trial, the whole point of litigation is to present the idea that you ultimately are likely to be successful at trial, that your evidence is going to be convincing. So your evidence can be physical evidence, it can be your expert testimony, but it's also the facts as presented by the eyewitnesses, who a lot of times are your insureds. And if those insureds are unreliable, it really it can have a devastating effect on your case. The case that Gus was asking me to speak about, so this was a elderly insured, and this was her summer home. So she only stayed there in the warmer months. And in the beginning of the summer, she would have a plumber turn the water on to her home. And at the end of the summer, she would have the same plumber winterize her home. So there was no water in the home. So what happened in this particular case was, when summer was ending, there was a miscommunication between her and her plumber, and the home was never winterized. And then as the weather got colder, there was a pipe freeze rupture in her attic, and it was a pretty big loss. So when I spoke with the insured, I had to have a pretty long phone call with her, just trying to sort of organize her thoughts and get the timeline straight in terms of her dealings with this plumber. What did you say to him? What did he say to you? What communications did you have that were in writing? What were the circumstances around your communications, to really kind of get a feel for, did the plumber drop the ball in some way for this home not being winterized? And after having the conversation with her, I felt that, there was liability to go around, but there was definitely a reasonable argument to be made that the plumber did not communicate well enough to the insured. And that was going to be the basis of our pursuit. So what was interesting is about a week later, I heard from the insured's adult son, where he was saying that the insured didn't like how that phone call had went. She felt that she was being interrogated in a way. And he explained to me that he didn't think it was my fault. She's just not used to talking to lawyers. And what I thought was just simply trying to get the facts out in a way that it was understandable and organized. She didn't like being asked questions in that way. So we had to have another phone call with her. Her son was on the line. And when I asked her the same questions, her answers were much more indicative that she was at fault. So she had become unreliable, but also unreliable in a way where she had basically made it so we can't pursue the case. So in the second conversation, everything she said about the plumber was like, nah, you know what? He probably didn't say that. That was probably just me thinking he said something he didn't say. Things along those lines. So when you have that situation, when you have an insured who cannot lay the factual foundation that you need to go forward, there's really not much more you can do with the case. Now, this may have been a case of an insured who just decided that she didn't want to be involved with litigation, and maybe that played a role in her memory. But regardless, the end result is she was unreliable and there was not much we could do with the case.
All right, moving on to the next issue that tends to arise, and that's the insured becomes incapacitated in some form.
I'm not laughing about an insured becoming incapacitated, but I am laughing about thinking about this story in my mind about what happened. So I did have a case that involved a lawn tractor fire, and the insured was using the lawn tractor, and he parked in his garage, and then he went inside his home. And a few minutes later, the lawn tractor caught fire. So about a month later, we're doing a joint site inspection with several parties placed on notice. Now, as it happened, and unfortunately, the insured passed away between the lawn tractor fire and this joint site inspection.
Hilarious, Matt.
Seriously.
His death was completely unrelated to the fire. He was an elderly guy, and it just happened to be his time. But of course, he wasn't our only witness to the use of the lawn tractor, the fire, but he was our best witness. And at the beginning of this joint site inspection, I spoke with our expert, pulled him aside, and I said, hey, just so you know, I hope you got all the information you needed to from our insured already, because he's passed away. So a few minutes later, our expert is addressing all the other experts and giving the factual background of what occurred, as you would expect at any joint site inspection. And then he's done, and everyone's going to start taking their pictures. And then he stops and he walks back in front of everyone and says, oh, by the way, the insured is now dead. And he walks back to me. And I pulled him aside and I said, hey, why did you tell everyone the insured is dead? And he goes, well, he is dead. I said, no, I understand he's dead, but no one asked you if he's dead. And a lot of these cases don't go to trial. A lot of these cases don't go as far as an insured deposition. There's no need for you to tell everyone our best witness is now dead. And he didn't seem to quite understand it. So sometimes that's a case of an expert not necessarily being litigation savvy. And, we're not asking anyone to lie. We don't want our insureds to lie. We don't want our experts to lie. And I told him, I said, look, if for some reason any other party comes up to you and randomly says, hey, just out of curiosity, is your insured currently alive or dead? Yeah, tell them the truth. But there's a difference between that and volunteering bad information about our case. So, but to the overall point, if your insured becomes incapacitated or deceased and they're an important witness, yes, it is a significant obstacle to overcome. And a lot of times you will not be able to.
R.I.P. lawnmower guy.
Yeah, fair enough.
Okay. Moving on to the next issue that tends to arise. Insured says unfavorable things about the carrier, the subrogating carrier, during depositions.
Not any of our clients, of course.
No, of course they couldn't. But I recently had a case where the insured pretty much told me at the very outset that she was not happy with the adjustment process, and she was not happy with the final amount paid out, and she was not happy with how the adjuster handled the entire process. And I told her, well, that's great, but the defendant in this case, in the subrogation case, wants to depose you. And I would just ask that you just answer the questions that are before you, and that you refrain from offering any opinions that have nothing to do with the question before you.
I have a feeling she
Unfortunately,
didn't follow that advice.
no, she did not follow that. She spent more than half the deposition talking about why she was owed more money, why the carrier was horrendous, not to mention why the defendant did such a great job, and that this evil carrier is probably making up this case against them. It was absolutely horrendous. So needless to say, despite my efforts to prep her, she simply did not want to do the carrier any favors. In a way, sort of tried to sabotage the claim. So we had to accept a much smaller settlement at the end of the day. And this was the top thing that the defense attorney brought up every time we entered settlement talks. So something to be aware of. Again, I think I prepped pretty well, but sometimes that's going to happen, and you've got to factor that in when determining the right range to settle the case.
All right, I guess I get last here, right? We're running out of time, so I'll be quick on releases.
And least.
What's
No,
the answer?
I mean, and not least.
Sometimes your insured doesn't want to sign a release, and sometimes the other side requires it, or at least is asking for it as part of the settlement. First of all, I should say that when it comes to release time, I personally do my best to avoid the insured, whether it's including language that specifically excludes them from this release, or not addressing them, or not having them sign it, just we can focus on the subrogation claim. But again, sometimes it's required, whether it's because, defense counsel on the other side is requiring it, or if there is some out-of-pocket uninsured losses. So, if you can't avoid that, and, you do have to get the insured to sign a release, typically, I take it pretty seriously. This insured is releasing rights if they're signing their name on there. So, if they want certain terms or they don't want certain terms, it's something you really have to take seriously. And because of that, the first thing I say is you should get a lawyer. You should have a lawyer review this, and I should deal with that attorney so that everyone knows what's going on. Everything is transparent. Oftentimes we do represent the insured's out-of-pocket losses in tandem with our subrogation claims, but sometimes, there's a possibility that, their rights or their interests may not coincide, and it's best that everyone has independent representation and counsel. So that's what I like to do, so that, everyone is fully informed before they sign away any of their rights.
I would say, while I do recommend that, it's very rare that the insured does retain counsel, but at least you've given that option. But usually they typically, in my experience, don't have an issue unless it's one of those issues where they're MIA and you can't get them to sign it because they don't want anything to do with the claim. All right. Well, clearly, as you've noticed, you could spend an entire episode on each one of these topics, and perhaps we'll revisit these issues in the future. But unfortunately, and I know you're all sad to hear this, we have to conclude this episode. The takeaway is that there are instances where a difficult insured can be very, very problematic and be devastating to a case and cause it to flatline. But we hope that you got some tips and some insight from our stories today that will help you save a subrogation case in those instances where the insured is being difficult or uncooperative. Any final words, Lian or Matt?
I'm going to apologize on behalf of Gus for all the medical puns, but, he couldn't help
That was
himself.
your idea. Well,
thank you.
I got nothing, Gus.
Thanks for listening to this episode of Subro Sessions. Be sure to listen to the next episode of Subro Sessions, which will be released on the third Tuesday of next month, June 20th, 2023 in this case. You could find past episodes of the podcast and relevant case updates on the Subrogation Strategist blog, all available at whiteandwilliams.com. Take care.